Hello, Facebook Live. Sean Yesner here for a behind-the-scenes recording of the Crushing Debt podcast. I've got a guest with me this week, Samantha Dammer. Say hi to Facebook world.
Hi, Facebook.
We're going to be talking about bankruptcy, the exciting world of bankruptcy, specifically business bankruptcies, Chapter 7s for businesses. So if you are ready, I will start the recording.
I am ready, Sean.
Cool. On this week's episode of the Crushing Debt podcast, Chapter 7 for Businesses with Samantha Dammer. So welcome to this week's episode of the Crushing Debt podcast. My name is Sean Yesner, and like I said in the intro, I've got a guest with me this week. She has been practicing just as long as I have, since 1998, which, if my math is right, at the time of recording puts us, right at about 19 years?
19 years.
19 years total. But she's been practicing bankruptcy in Florida specifically for about the last 10 years. And she and I are peers. One of the things I like about the bankruptcy bar, at least here in the Tampa Bay area, is that at some level we're competing for the same client. We're competing for the same dollar. But that's not really the attitude that I found within the Tampa Bay bankruptcy bar. We're all collaborative. We're all friendly. We're all... even though we might be competing at some level for the same client, we support each other. I mean, we've handled cases together. We've done all that kind of stuff. So I am happy to have Samantha Dammer with Tampa Law Advocates as a guest on the Crushing Debt podcast with this episode. So welcome, Samantha.
Thank you, Sean. Thank you for the opportunity. It's exciting to be here, and I couldn't agree more as far as the bankruptcy bar. We're a good crowd. It's a good group of colleagues.
I often explain it to clients where we can be at each other's throats when we're in court, but when court's over, we can all go out and have a beer.
Exactly.
And be friends. So one of the things that I wanted Samantha to come on and talk about, her practice handles both consumer and business bankruptcies, Chapter 7, Chapter 13. Do you handle 11s as well?
We do, yeah.
So Chapter 11s as well. And a lot of people get confused between 7, 13, and 11. And I've got podcast episodes, and I'm sure Samantha has information on her website about the differences in the chapters. But what I wanted to talk about specifically, and Samantha wanted to talk about, I get clients that come in a lot and say, well, my business, I think we're there, where I think we're at a point in time where the business has to file a bankruptcy case. And a Chapter 11 won't work for the business because it's not a situation where we're going to try to salvage the business, where we're going to try to keep the business running. So let's just do a 7, wipe everything out, and kill it. And my response has always been, well, that's good, but I've always sort of been against Chapter 7s for business. I've done them, but I've been against them because of the fact that they don't get a discharge. But I know that you've done a lot of Chapter 7s for businesses, so I wanted to get your take on it.
Sure, and that's really what I wanted to talk about, is why a business entity, whether it's an LLC, whether it's a corporation, would need to actually go through a formal process of filing a Chapter 7 to dissolve, as opposed to just simply not letting it renew on Sunbiz, letting it dissolve, walking away, forgetting about it, and that sort of thing. And it's as a general rule, I usually will try to avoid the formal filing of a Chapter 7 for a couple of reasons. But if we have to do it, we have to do it. And one of the reasons that we may have to do it is, Sean, and I'm sure you've seen aggressive creditor attorneys who will get a judgment against the defunct business, which has failed, which has nothing, which has no assets, but yet they'll use that judgment as a way to just legally harass the principal of the business. They'll do depositions. If you don't show up for the deposition, they do, try to hold you in contempt, things like that. So filing the Chapter 7 and formally dissolving the business through the bankruptcy process is a way to end that. That's probably the main reason I file them.
And I've seen before too, where in some cases, they maybe try to pierce the corporate veil. So those of you that are not attorneys, that are not attorney speak, they try to say that the way that the business was wound up was improper, or that the owner was using the business so that there was really no distinction between the owner and the business. And so they try to use that as a way to squirrel in and go after the business owner directly instead of picking at the business. That's been one reason that I've said, let's just do a 7 and eliminate it.
Yeah, yeah, there's that, and then there's also just the intangible benefits. Really, I have a lot of clients. I'm sure you have a lot of clients that they're the sort of people that they've never been in any sort of financial trouble. They have this business. They know it didn't work out, and they want to feel like they've got closure at the end of the day. They like the symbolic aspect of being able to hand the keys to the trustee and know that it's no longer something they have to worry about.
Right. So other than the fact that there is no discharge, and maybe we can talk about that, because I think that's one of the bigger questions that I get, so that if there isn't a discharge, what happens at the end of the Chapter 7? How does the Chapter 7 work if there's no discharge?
Yeah, what happens is assuming that there's some assets that are not encumbered by liens or whatever, the trustee will liquidate everything, just like in a individual Chapter 7 where there's non-exempt assets. Because remember, the business has no exemptions. So anything that the business entity owns gets liquidated through the bankruptcy process. You can't save things, so that's probably one of the biggest drawbacks. The other thing that happens is the corporate representative, whomever signs the bankruptcy petition, has to show up at a 341 meeting, just like any other bankruptcy. Right. And that's one of the biggest drawbacks is if there is somebody that's using the business as their personal piggy bank, if there's money going back and forth, that corporate representative could actually be exposing himself to some personal issues. Right. So that's a huge pitfall, and a lot of times that's a reason alone why we hold off on filing a bankruptcy for the business. So what are some of the other dangers in filing a Chapter 7 for a business, for a company? Well, along the same lines, if you've got a principal of the business who's taken money out of the business right before filing a bankruptcy, they could face adversarial action. They could be sued. The trustee can actually go after them. You've seen cases like this. I've handled cases where it's not. I call it, hey, put that back. It's when a transfer is not something that's a good thing. You put that back. The trustee's going to say, well, wait a second. That money needs to come back into the bankruptcy estate on behalf of the business debtor, so it could be distributed. Yeah. So you could end up, finding yourself in extensive litigation if it's not done right. And that's the whole point of the Chapter 7. The trustee is taking the assets of the debtor, in this case the business, turning those assets into cash, and then using that cash to pay back any creditors of the business. But even though there's no discharge, after those creditors have been paid, they just simply walk away, because there's the creditors walk away in essence from the debt, because there's nothing else left for them to receive, right? Right. There's nothing else really there. The question I get a lot of times, I have somebody that a small business, a small restaurant, something like that, where the owners, the principals of the business, want to continue in the same industry. And the big question is, can they buy back the assets? Can they restart up under another entity? And, the answer is sort of, it depends. It depends. Typical attorney answer, it depends. Yeah. But yeah, that's a good question. The entity itself still, even though it doesn't get a discharge, it's still on paper. So they need to really understand that it doesn't go away. It's still an entity that still exists, but it just can't be sued for those debts anymore. Right. And then the flip side of that coin, a lot of times what I've told people is if it's a business that's truly, we're not interested in restarting this business, we as the owners are not interested in getting back into this line of business, then you do the Chapter 7, the business goes away, and then the owner just goes on doing their own thing, whatever else it is they want to do. And hopefully they haven't signed any guarantees. And so they literally just walk away like a normal Chapter 7 for an individual. Right. And the guarantees is a good point, Sean. Because what we usually do is, we have two scenarios. We'll either file the bankruptcy for the business entity and hope that everybody goes away. But a lot of times after that's all said and done, if the owner signed a personal guarantee, they may be facing a personal bankruptcy as well. Right. And vice versa. A lot of times we'll do a personal bankruptcy, and then we'll run into that scenario where you get the aggressive creditor's attorney who continues going after the business entity that has nothing. And then we have to decide whether we have to do something on that. So it can play out one of two ways, really. Right. So we're getting near the end of our time. Is there anything else you wanted to talk about? Anything else you wanted to bring up? That's really it. Really, just the only other thing I would say is there's a lot of attorneys that will just automatically say, "Oh, you have to file a formal bankruptcy for the business," and that's not necessarily true. I just want people to understand, there might be other options, and they really, shouldn't automatically file a bankruptcy lightly, because the other thing, as you know, Sean, with the Chapter 7, is once you're in, you can't necessarily get out.
Right. And I've told that to clients all the time. Someone will call me and say, "Hey, I need to file a bankruptcy." And sometimes I talk them out of it because it's not the right choice for them. A lot of times it is, but sometimes it's not. So if there's somebody out there that wants to talk to you about filing bankruptcy or filing bankruptcy for their business, what's the best way to get a hold of you?
They can call my office, 813-288-0303, or they can go to our website, www.tampalawadvocates.com. Exactly
how it sounds, right? Spelled exactly how it sounds.
Yes.
Cool. Well, I want to thank you for being a guest on this week's episode of the Crushing Debt podcast. I do want to tell the listeners there, if you all are interested in these topics, contact Samantha, contact me, check out our websites. I'll put all the information about Samantha's contact information, and then always my contact information will be in the notes if you're listening to the podcast. We appreciate you tuning into this week's episode, and we look forward to speaking to you in the next episode of the Crushing Debt podcast. Cool. So we are done recording. We are still on Facebook Live.
Oh, okay.
So the camera's still recording
all
us.
Right.
So thank you guys for tuning in.
Thank you, Sean.
I don't see that anyone's watched our Facebook Live, but it'll be preserved for on Facebook, and we can YouTube it. And typically the running joke here is my staff tends to watch the Facebook Lives instead of working. So at least that's good that I know they're working. So
that's good.
Thank you, Facebook Live. We'll go behind the scenes again when I have another guest here in office, here in studio. I don't know what to call this, but here at my office, we'll do a Facebook Live again when I have another guest. Thank you guys for watching the video. Thank you again, Samantha.
Thank you, Sean.
And I'll cut the feed now.